Have viewers, as you well aware that I am Dr. Jetling Elosa, running a YouTube channel called Law Speeches. So first of all, I humbly request all of you to join in my channel to watch my lectures on the various facets of law as well as the world affairs. You know, India Parliament has enacted three landmark criminal law acts in 2023, and those are coming into force by 1st of July 2024. You know, the criminal system is important to running a country because nowadays the criminals have become so active and innovative, and they're doing their crimes or offenses in different new manners. To tackle this, we need a new laws because if you see the Indian system, criminal justice system, the old acts like the Indian Penal Code of 1860 and the Criminal Procedure Code of 1973 or Indian Evidence Act of 1872. Those enactments were made by the Britishers. Those are very much relevant during the time of making such enactments. But there is a lot of changes have been we observe in the society. I just told you that criminals also became so entrenched in the commission of the crimes in different way, sitting across somewhere, they committing the crimes and they cheating the gullible public, and that is the reason we have the lesser rate of punishment. If we observe the National Crime Record Bureau, hardly we could see less than 5% of criminals have been got punished by the courts because of the various factors, including the outdated enactments. To tackle this issue, the government of India had enacted three important criminal legislations in 2023. Those are replacing the British inherited laws. The number one is the Indian Penal Code, which is now we enacted, and we are calling it as the Bharatiya Nyaya Samhita. And the second enactment is Bharatiya Nagarik Suraksha Samhita, which is replacing the Criminal Procedure Code. Then the third important enactment, that is the Bharatiya Saksha Samhita. So it is replacing the Indian Evidence Act of 1872. So we discuss in today important provisions and what are the changes which have been introduced to the criminal law justice system in India by enactment of these acts. So we go by one. That is, first we will take up the BNS. That is a Bharatiya Nyaya Samhita, which is replacing the Indian Penal Code of 1860. So here in Bharatiya Nyaya Samhita, there are 358 sections are there. So it means that we are abridged the Indian Penal Code, which was there in 511 sections. And in this act, we are added 20 new kinds of crimes under this code. And out of in which 33 serious offenses, for that the punishment has been increased, and 83 offenses where this BNS provides the awarding of the fines. And there are 23 crimes have been categorized for awarding of compulsory punishment. And another important aspect, as the most of the Western countries are adapted, that is a doing of performing the social service. So the concept has been originated from the Scandinavian countries like Norway, Denmark, and Sweden, and it was extended to the other parts of the Western Hemisphere. That is, we also incorporating six offenses. If they does the six kinds of offenses, the accused persons have to perform or render the social service. So that is a new sort of thing we are introducing to our penal code is concerned. And the penal code, the coming forcing of the penal code also provides the human trafficking or the begging are becoming a serious offenses, and which attracts severe punishment. And also this BNS also providing that promise to marry and whereupon indulging into the sexual relationship with a promised girl or boy, if they are not discharging the promise, the so-called promise, they are liable for the 10 years of the punishment and also the heavy fines. And this BNS also provides that there is a certain guarantees should be there in the employment, in the promotions, in marital relations, and in economic crimes. If the persons are involved in those activities, they're liable for the heavy punishments. Then the Act BNS also prohibits the illegal activities like the kidnapping, dacoity, vehicle theft, forcibly occupying the other's land, constructing in others' land without their permission, and the contracting, killing activities, murder, or economic offenses, cyber crimes, narcotic and substances offenses, transportation of the arms, ammunition, all those offenses which I mentioned, they are liable for heavy punishments. The BNS provides. And if the BNS also provides that if the woman was forced for the prostitution, then any sort of economic crimes, it be considered as a serious crime and they're liable for the heavy punishments. Then, if the criminals are indulging into the causing damage to the national unity, integrity, sovereignty, economic security of the country, and extremism or terrorism activities, they are heavily punished by the, the BNS. So it is a reformatory as well as a revolutionary enactment enacted by the parliament. And the second important enactment which is coming to force from the 1st of July of 2024, that is the Bharatiya Suraksha Sanhita, which is having 531 sections, whereas the outgoing Criminal Procedure Code is having just 484 sections, but we added the new sections. Totally 177 sections were changed which are there in the outgoing Criminal Procedure Code. And 9 new sections were added into the BSS, that is the Bharatiya Suraksha Sanhita, and 32 new subsections also been added, and 14 sections completely removed from the Criminal Procedure Code. And so this is also giving a kind of sharpening was made to the Criminal Procedure Code, because criminals also sharpen their brains, their acts, and their deeds to tune with those. This has been sharpened into in this BSSS code. And the BSS code also provides that there should be dispensation of justice in 35 offenses. Early dispensation. They should not delay in dispensation. And for the trials, an important section is also added. If a person first time commits a crime, if he is arrested, and his arrest period would be considered, 1/3 of his arrest period would be considered, and after 1/3 of his arrest time, he has to be released, enlarged on the bail that also been there in the BSS, Bharatiya Suraksha Samhita. But in case of the life imprisonment cases, this kind of arrangement is not being accepted or to be followed. And BSS also lays stress upon the forensic sciences. Police, they have to, while they are investigating the offenses, they have to record in the video manner, electronic manner. That has also been one of the important proviso which we could find place in the Bharatiya Suraksha Samhita. And in case of the sexual offenses against women, the medical experts, practitioners, they should have to submit their report within 7 days of their examination. It is a must and compulsory to give the sanctity to their report or examination. That also been incorporated in the BSS. And the new act also provides that at all possible time, the in 90 days, the charge sheet should have to be filed in the competent court. That is a important burden or obligation is provided under this new BSS Act. If due to certain conditions, if the law enforcement agencies they fail to provide or submit the charge sheet within 90 days, in such scenario, they have to take the court permission, citing the reasons for not submission, and they take another 90 days. So without court permission, it is not possible. So they have to get the court permission for extending the time limit for submission of their complete charge investigation or charge sheet issues are concerned. And a court which hears the arguments in criminal cases and judgment should have to be delivered or to be delivered within 30 days. If the court is failed to deliver the judgment within 30 days and it can be extended for another 30 days, but while extending the another 30 days, it has to mention the date for extension. It has to mention the ground for extension of the giving the judgment. So this is another remarkable enactment because we have number of cases have been pending in the courts. The another important act, that is the Bharatiya Saksha Abhiyan, Niyamo. So this Bharatiya Saksha Abhiniyam is replacing the Indian Evidence Act, which was made way back in 1870s, 18th century. And there are around 170 sections are there as in this Bharatiya Siksha Abhiniyam. And in old act of Indian Evidence Act, 24 new sections have been completely changed or overhauled, and 6 sections have been removed. And the new act has added 2 new sections, 6 subsections, and there is a complete overhauling of the British words which were there in the Indian Evidence Act. So they are deleted. And the new Evidence Act, that is a BSA also providing the electronic evidences. So already we have in the old act also amendments were made, electronic evidences have been incorporated, but here electronic evidences have given utmost important in the new act. And the law enforcement mechanism, our police, they have to record their investigation or their entire process in the electronic methods, electronic modes. And And the Act provides that electronic evidence be classified as the secondary evidence. So they generally we are presuming that this is only criminal law. No, no. The Bharatiya Saksha Abhiniyam both applicable to the criminal law as well as to civil law. But notion is that only criminal law, criminal, that is a wrong. That we have to observe here. So then, because we have seen electronic evidences can be manipulated because we got such a technology where manipulation of electronic evidence became a common. So, but the world is changing. We also to make a changes into it, into the forests. Then the some other important issues are concerned with these acts. That is the earlier the popular section in the Indian Penal Code, that the 302 now became the section 99 in the new act. So punishment murder is now be there in the section 99 of the new act. Then the new act also provides the serious punishments in case of extremism, terrorism, and for that even death penalty can be imposed. That has been prescribed in the Bharatiya Nyaya Samhita. Then we now discuss the police powers. So the new act also enhancing the law enforcement of police powers, and they have to investigate, impose challenge. For that, they have to compulsory the videographed. That is a burden is castigated upon the police officials, and EFIRs can be filed from anywhere, electronic FIRs, and zero FIR also been given the legal status in this act. So we can file if a crime is happened in one part. We don't know the jurisdiction of the police station, but you can file the wherever you could be. That be called as a zero FIR, and later the case will be transferred to there. Then all the criminal process should be digitalized. Case diaries, charge sheets, CDs, cross examinations, all those things have to be digitalized. That is another good aspect of the, because digitalization will give authenticity and will give the document for the longer period for survival. So that is the reason it has been make it as a mandatory, and the forensic sciences have been given a higher value in the new enactments. And so the New enactments were made to enhance the punishment ratio to 90%. Now we have only 5% or 1 or 2% higher than lesser. So the main motto of this act is to go for a higher punishment. And there is a accountability also being castigated upon the police officials, advocates, and judges under the new enactments. And another important thing we have to know that if the police makes an arrest, they can keep a person. While keeping, they have to inform to the family members that arrest is being made, and it is the responsibility of the police. The they should not cause any sort of thing to the arrested person. And and if the case has to be withdrawn, if the punishment is for 7 years, then the victim should be heard. Till then, the case cannot be withdrawn. That is also an important aspect which is made. And the superintendent of polices and the DSPs, deputy superintendents of polices, have given power to declare unlawful assembly. Earlier, the power was there in the case of the executive magistrates, district collectors, or the revenue divisional officers. But now, that power has been vested to the or transferred to the in the hands of the SPs and DSPs. But the new enactments are not free from the criticism. There are number of still loopholes are there in this act. While passing the bill, the opposition parties they are claiming that they have not properly consulted. And opposition was when they were not in house, these enactments were enacted or passed. So that was the another thing which is there. And and the if you see the closely observe the act, if a person is arrested as per the fundamental rights of the Constitution of India under Article 22, he should have to be produced before the nearest magistrate within 24 hours. But here, the acts are providing that police can keep a person for 15 days, stating that investigation is going on. So that is against the principles of the Constitution of India, the fundamental rights. I doubting that it may not stand before the courts, constitutional courts, what I meant to say. Then it is against the spirit of the Constitution of India, this sort of a provision. And again, the sedition, waging war against government of India, have been added without any a meaningful definition is provided. So that may lead to it affects upon our fundamental right of speech and expression. If I criticize the government, can it be called as a sedition? A propagation of the sedition? There is a number of criticism is a fair criticism, analytical criticism, many criticisms are there. So the government cannot brand that it is a sedition. So that the perfect definition is not given to the sedition in these new enactment acts concerned. I the SP level and ESP level officers conferment of the banning assembly Earlier it was in the hands of the district collectors or magistrates and the RDOs. Now the power is given to the police officers. They may lead to misuse or abuse. So that is another grave area of this enactment is concerned. Then the all the cyber crimes and have been tried under the Information Technology Act of 2000. But now the act is itself is incorporating the cyber crimes, and we have to see whether the cyber IT act is to be availed or not. Only the current enactments provisions should be filed. That would be take time for to think over. Then there are some state governments like West Bengal and some other opposition parties led governments. They have stating that the new enactments are against to the federalism, principles of federalism. You know, we have distribution of powers are there. The constitution guarantees such power. That is the reason West Bengal government recently came out with a statement that they are not going to implement the new acts. So it may be a cause, a friction between the states. So that has to be think of. And so, the old acts are relevant to do for that period. But we should not say that the old acts are not so valuable. In many African countries like Tanzania, Kenya, and most of the East African countries, they have borrowed our enactments and they included the criminal system as basing upon our criminal system. They have succeeded. We also succeeded. But, change of times demands we have to change. Time changes. We have to change. Society changes. Circumstances changes. So that is the reason the government has enacted these three important criminal law justice systems for into statute books by 1st of July by 2024. These enactments are coming into force. So we see that there should be proper implementation. Lord Acton, he stated that power corrupts. Absolute power corrupts absolutely. So we are giving power to a group of persons, maybe law enforcement agencies, maybe judicial officers or administrators, but they have to implement it in proper way to provide justice to the gullible public and to prevent crime, because by committing the crime, the powerful people have been have been avoiding the punishment. That should not be there. Law is equal to each and everybody, irrespective of our status, caste, creed, education, whatever it may be, all are equal before the law. That principles are there in the Constitution of India and the Article 14, 15, 16, 17, 18. So the new enactments and should be, I hope that it may become a successful in bringing the harmonious, peaceful society in our country. Thank you for, in next class, I will go in details of it, but thank you for listening to my this lecture. And once again, I call upon all of you to subscribe to my channel. My channel name is Law Speeches, which is available on the YouTube platform. Thank you, one and all.